Hey guys, today I have something really exciting to share with you. It's a list of Canada's worst censorship laws. Now, I worked with my colleagues at the Canadian Constitution Foundation to go through literally hundreds of bylaws in Canada passed by cities, towns, regions, and villages that censor speech. And we created an award for the worst censorship laws. And this award was named by you, our supporters. It's called the Municipal Muzzle Award, and it was selected by our amazing CCF supporters by a poll we sent around by email. If you didn't get the poll, it's because you are not signed up for our email updates, which you can do at the ccf.ca/freedom update. Pause this video and go sign up right now because I don't want you to miss out on being a part of this community that we're creating here together. So here it is, the Municipal Muzzle Award, along with our report, which you can download at the ccf.ca. I cannot wait to tell you who won. So to do this report, we worked with some interns from Osgoode Hall Law School, and we did many hours of research looking up individual towns, cities, and regions. We considered hundreds of different bylaws, and we found at the municipal level, there are basically four types of laws that censor people. First, there are content-based speech limits on streets and in parks. Second, there are content-based speech limits on private property. Third, there are content-based speech limits on the speech of city councilors. And fourth, there are content-based speech limits on residents' speech at public meetings, council meetings. So I'm going to give you some examples of each of laws from each of these categories that we considered for the award. And at the end of this video, I'm going to tell you who won. So in that first category of censorship laws in public places, we had a look at the town of Grande Prairie, Alberta, and it has an anti-bullying bylaw that applies to any public place and any other place. So it applies to streets and parks, but it also is city council claiming they can regulate mean words uttered anywhere, even in your own private home. And it applies to electronic communication as well. So anything you say that was mean or salty on Instagram, or an argument you have with your child in your house, that could come under the jurisdiction of this crazy bylaw in Grande Prairie. And it's the bylaw officers who decide what comments do or don't warrant a ticket, which is $250 for the first offense and up to $2,500 for a second. Now, there's also a bylaw in Laval, Quebec, that is an anti-blasphemy, but also anti-whistling bylaw. So in Laval, Quebec, you can theoretically be fined for insulting God, or even shouting, blaspheming, swearing, whistling, singing, cursing, or insulting in public parks. Now, in Châteauguay, Quebec, there's also a no rude gestures bylaw. This one might get me in trouble. And it applies to pedestrians, cyclists, and drivers. So you can't curse or make rude gestures in any place, including online. And that means, flipping the bird to the guy who cut you off could result in a fine in this Châteauguay, Quebec town. A number of municipalities also have what are called Antigraphic Images bylaws. Some include towns like Airdrie, Alberta, Burlington, Ontario, London, Ontario, Calgary, and New Westminster, BC, as well as Waterloo, Ontario. These are kind of in a lot of different communities. And these bylaws were passed to stop anti-abortion protesters who would picket with images of aborted fetuses. Now, I have to say, I personally do not like seeing these images. I find them very upsetting, but that's sort of why pro-life activists use them. They believe that having people see these images will help convince others of their position opposing abortion. And as uncomfortable as it makes us, discomfort is the price of living in a democracy with free expression. There's no right to comfort. There's no right to be free from offense, but there is a right to express your deeply held conscientious beliefs using words or images of your choosing. And these anti-graphic images bylaws are a form of censorship. Now, there are also restrictions on speech on private property. And this is important because secure property rights are a necessary foundation for many other rights, especially freedom of expression. Let me explain why property is so important for expression. If you are not allowed to own or publish books or sell flyers, signs, put up posters, do you really have a right to free expression if you can't do those things? If you can't use your private property for a political purpose, do you really have a right to political speech? That's why these private property speech restrictions are so problematic. And all of these issues come to a head when municipalities impose restrictions on how people can express themselves on their own property. While it's acceptable to put limits on time, manner, and place restrictions that limit, for example, rowdy parties late at night or restrict the use of loudspeakers or stereo systems, there's a big difference when you get into restricting the political messages that people put on their own property. That is not acceptable in a free and democratic society. But many municipalities enact laws that do just that. Until very recently, the city of Brantford, Ontario had a property maintenance bylaw that prohibited murals on private property unless they depict scenes relating to the natural and cultural history of Brantford and the outlying area, which enhance the streetscape and are visually attractive. Now, the city has no business at all setting standards for aesthetic beauty or determining what type of artwork people want to display on their own property. It's completely insane to me that Brantford would only allow pro-Brantford art. And what would that even look like? Is it a picture of Wayne Gretzky and horses? That's kind of what I think of when I think of Brantford. Is that the only acceptable use of my private property for artwork? This is just completely absurd. And it's insane that Brantford enacted something like this. But they did recently repeal it. So thank you to Brantford for repealing that bylaw. And I have to say, you really dodged a bullet here, because if you hadn't, Brantford was actually going to be a runner-up for the Municipal Muzzle Award, but alas, now we will be awarding it to someone new who I will be announcing at the end of this video. Now, Brantford's bylaw may have been the worst when it comes to regulating art, but other towns have similar laws, for example, Ottawa and Kingston. In Ottawa, murals are only allowed if they reflect and depict the culture, history, or visions of artistic expression in a tasteful and positive manner. Now, that is nearly as bad as Brantford's requirement, because, art and taste are entirely subjective, and I don't know if I want to leave that in the hands of an Ottawa bureaucrat to determine what is in good taste. Now, in Caledon, Ontario, a bylaw prohibits signs depicting violence, nudity, or sexually explicit conduct, or any message or content that is deemed by the town to be offensive or negative. It's the second part of this bylaw that is the problem. What is offensive and what is negative is entirely subjective, and it can actually change with time. In a previous era, advocating for example, the equal rights for gay Canadians, that might have offended the morals of many people or even most people in that community. And this law at the time would have prohibited displaying signs that call for equal rights or pride flags if they'd existed at the time. And today, it might prohibit a popular sign that is critical of a political leader, or any other sign that some bylaw officer or nosy neighbor or self-righteous politician doesn't like because they think it's negative and it offends them. It bears repeating, in Canada, there is no right not to be offended. Now, the third category of censorship laws we deal with in this report are restrictions on speech by elected city councillors. So when individuals step up to serve as mayors, reeves, or councillors, they don't suddenly lose all their rights to freedom of expression. But you wouldn't know that looking at the procedural bylaws and codes of conduct that many municipalities have put in place. Now, one very common type of speech restricting bylaw targeting elected representatives is a bylaw that claims to ban disrespecting or criticizing decisions made by council as a whole. For example, in Belleville, Ontario, there's a bylaw that says, in no event should a member express a position that is disrespectful of the decision of the majority of council, a board, a commission, or a committee. But what if council, a board, a commission, or a committee makes a terrible, egregious decision that is not worthy of respect? Shouldn't a councillor who has been elected to serve her people be able to speak out about that? The charter guarantees the right to do so. So I think that these laws are really vulnerable to constitutional challenge. And Belleville is not alone. There are other cities that ban councillors from disrespecting or criticizing other members of council, like Ajax, Ontario, where members shall not publicly criticize a member of staff or another member of council, or Clarington, Ontario, or Peterborough, Ontario. These bans in these communities are all constitutionally suspect. Some municipalities go even further and engage in tone policing, literally. In Coquitlam, BC, no member or person attending a meeting may use rude or offensive language or tone or manner of speaking to express a point of view, opinion, or allegation. So who's to decide whether a councillor's tone reflects unfairly upon the character of another person? And how can they be prevented from using an angry or critical tone in a society where there's no right not to be offended? You know, even married couples are encouraged not to fight about the tone of their spouse's voice. So I don't know, maybe these city councilors just need some therapy. Even more absurd, though, are laws that ban criticizing the royal family, and there are a lot of them. In North Bay, Ontario, no member shall speak disrespectfully of Her Majesty the Queen, I guess that needs to be updated, or any member of the royal family, the Governor General, Lieutenant Governor, or a Minister of the Crown. The Ontario municipalities of Ottawa, Milton, Peterborough, Thunder Bay, and Burlington all have similar rules. So what does this mean? Can a councillor not point out how cringy Meghan Markle's Netflix series was? She is technically still a member of the royal family. Or what if a city councillor didn't like the recent speech from the throne delivered by King Charles in Ottawa? Or what if they just didn't like Camilla's hat? Why can you not say these things? But more seriously, I actually think councillors should be able to express criticism of the royal family or an anti-monarchy sentiment more generally. And we have that right in a free and democratic society. There are also laws that ban so-called misinformation by city councillors. In Langley, BC, councillors are banned from promoting, quote, misinformation, just as they are in Moncton, New Brunswick, where no councillor can use social media to publish anything that is dishonest, untrue, or unsubstantiated. And in Richmond Hill, Ontario, when using social media, councillors shall not publish anything that is dishonest, untrue, or misleading in any way. But whose version of truth, whose version of the facts will prevail when there's a debate over the truth? You know, as we saw during the COVID-19 pandemic, what is considered misinformation by the establishment one week will be uncontroversially true the next week. Did masking do nothing? Because they had to tell us masking did nothing so that the masks could be saved for healthcare workers. Or was masking necessary and should be mandated and it's the only possible solution to the pandemic? Did the virus come from a Chinese wet market or did it leak from a lab? Depending on when you made those statements, you were actually spreading racist misinformation. Governments are a terrible judge of truth and usually the biggest proponents of spreading misinformation. And it's unconstitutional for municipal councils to ban their members from putting forward different theories on matters of public policy. To find otherwise would actually defeat the purpose of free speech, which is to get to truth and allow for the democratic process and democratic governance to prevail. Now, there's a lot more to say on speech restrictions on council members, particularly these codes of conduct that get weaponized to punish unpopular councillors, but you can read more about that in the report. I want to talk about the next way municipal bylaws silence speech, and that is at public meetings. Now, these are laws that restrict what can be said or how public meetings can run, what members of the public can say at these meetings. And look, I get that rules for conduct at public meetings are important, City council meetings can get really disruptive, especially when there's a hot button issue being debated. And democracy by its nature is loud, it's messy, and it does make sense for local governments to have rules in place so that debates can proceed in an orderly fashion, so that everyone can be heard, and so that decorum can be maintained. For example, many towns have rules in place to ensure that councillors and members of the public can't heckle or drown out debate through loud shouting or sustained applause. And there are generally rules about speaking out of turn in order to minimize interference with the meetings so that they can actually take place. These are what lawyers call time, place, and manner restrictions, and they're perfectly acceptable under the Charter because they don't undermine freedom of speech. But there are other bylaws that do unjustifiably limit the right of members of the public to speak at public meetings and participate in their local democracy. And these are content-based restrictions. And in my view, they violate the Charter-protected right to freedom of expression. One example is a bylaw in Regina, Saskatchewan, where the mayor may interrupt and stop a delegation from being given by a citizen if, in the mayor's opinion, the presenter is not speaking respectfully of the king. There is like this obsession with the king and queen in Canada. In these municipalities, I do have to say, there are a lot of bylaws about insulting the king. Now, in Brandon, Manitoba, the laws go even further. The mayor can stop a delegation if the presenter uses offensive words in referring not just to the king, but to any member of council, any official or employee of the municipality, or even another member of the public. The terms respectful and offensive, again, are subjective. What offends one person may not offend another. And what one person views as respectful, another may find disrespectful. Having your voice heard or silenced in Brandon council meetings will now depend on how thin the skin of the mayor at the time is. Now, mean and scary words are not the only thing city councils are trying to silence. In a number of cities, like Guelph, Ontario, members of the public at meetings cannot bring signs, placards, buttons, brochures, or pamphlets into meetings. So this could result in someone being ejected for something as innocuous as wearing a Remembrance Day poppy or a Canadian flag button. Of course, we know that this rule will be enforced selectively. So people with buttons that councillors just don't like are the ones who are going to be targeted for removal. There's a similar law in Kingston, Ontario, where the ban is not just on signs, banners, emblems, and flags and placards, but also on just conversation among the public. In Cambridge, the law goes even further. They have a law prohibiting signs, placards, pickets, and banners, not just in city council meetings, but at City Hall itself, as well as at nearby historic City Hall. The law also prohibits clothing with political messages. So this means citizens who might want to show up in a t-shirt that says lower taxes or save our park, they will not be allowed inside the town square of City Hall. Signs and banners are a way that people who might not have political power or resources express their views to the people that they're elected, and Cambridge wants to silence that. Now, until very recently, there was an especially egregious bylaw in Whitehorse in the Yukon, but we successfully had that bylaw changed through our advocacy at the Canadian Constitution Foundation. In Whitehorse, there was a civility policy that passed in August of last year that banned citizens from engaging in microaggressions, which are defined as any comment or action that subtly or unconsciously or unintentionally expresses a prejudiced attitude towards a member of a marginalized group. So yes, even unconscious thought was now forbidden in Whitehorse. The policy also banned bringing any signs into the venue where council was meeting, wearing buttons, pins, or other attire that was, quote, disrespectful and had inappropriate messaging. So we launched a lawsuit against Whitehorse because of this policy. And as a result of that lawsuit, they actually amended the policy just recently in May of 2025 in order to remove a number of these provisions. So we are thrilled that our advocacy was able to result in just a little bit less censorship in the Yukon. Now, I want to get to our winners of the Municipal Muzzle Award this year. So the second runner-up is South Bruce Peninsula. So this is a town in Ontario, and this town was sent in as a nomination by a CCF supporter. So if something's happening in your community, please let me know, because I'm going to be heading to South Bruce Peninsula now to give them this award. So they have an outrageous bylaw that prohibits picketing in any public space unless it is authorized by the town. And picketing is defined as any activity associated with protesting, objecting, and it may include the display of signs, placards, flags, shirts, hats, etc., which portray a message or symbols or marks, or even silence or shouting or chanting or singing. And so this is ridiculous. I mean, even silent protests are illegal according to the geniuses who wrote this law in South Bruce Peninsula. This cannot possibly be constitutional. The right to protest is a fundamental one protected by the Charter, and this blanket ban on public protests without permission just cannot be justified in a free and democratic society. You do not need the government's permission to protest or picket. Now, the first runner-up is a town that I have mentioned a few times already because it's cited repeatedly in this report, and that is Caledon. Caledon is a town just north of Toronto, and they have got a lot of bad bylaws. But the one that got them the runner-up bylaw is the prohibition on insulting important people. This particular bylaw is a part of Caledon's rules governing conduct and decorum at council meetings. And, as I said, for the most part, rules about decorum make sense so that the meeting can be conducted in an orderly way. But some towns, like Caledon, take these rules too far by targeting speech based on its content. And among these is Caledon as the worst offender. In Caledon, a bylaw prohibits both members of council and members of the public from speaking in meetings and using indecent, offensive, or insulting language, as well as speaking disrespectfully of certain politicians, whether they are federal, provincial, regional, or members of the council or employees of the town. So what exactly is disrespectful? That's entirely subjective. But the most important thing is that we have a right to criticize our elected leaders using whatever words we choose. It's a precious right, and it should never be curtailed. You have a right to say what you think as an elected representative of other councillors and other levels of, and politicians at other levels of government, even at council meetings. And finally, our winner of the 2025 Municipal Muzzle Award is the City of Calgary. Now, you have heard me talk about Calgary before, and I think you probably know what bylaw I'm going to give this award for. It is Calgary's safe and inclusive bylaw that bans protests. It is a form of bubble law, and this is an Orwellian-named law that prohibits protests on specified topics selected by the government in large geographic areas. It creates a bubble around certain places where protest is just not allowed. Calgary's bubble zone law is especially dangerous because it gets the government involved in deciding what topics can be protested and what cannot. And once the government is deciding the content of speech and protest, that right ceases to have any meaning. And the law forbids these specified protests within 100 meters of an entrance to a city-operated library or rec center. And it defines specified protest not just as a large gathering, but as any expression of objection or disapproval about the government's long list of forbidden topics like race, religion, gender expression, gender identity, place of origin, family status, disability. The list goes on. And it doesn't even have an intent requirement. So the bylaw could apply to a random outburst from a person suffering from mental illness at the drop-in center right beside the Calgary Downtown Library. It could also apply to a private conversation overheard on the street if the person who overheard it thinks that the conversation expressed objection or disapproval. It also, of course, would apply to gatherings protesting various government policies, something that Canadians have a right to engage in and is protected under Section 2B and 2C of the Charter. This bylaw is explicitly aimed at eliminating speech based on the message the city doesn't like and aimed at protecting the emotional safety of residents, which the court has repeatedly said, for example, in the Supreme Court case of Ward, offense is just not a justifiable reason to limit expression. And one of the reasons we gave Calgary the Municipal Muzzle Award this year is because they were the first municipal bubble zone of this kind, and they inspired other communities to create copycat legislation. So after Calgary banned protests, so did Vaughan, Brampton, Oakville, and most recently my hometown of Toronto. So congratulations to Calgary on inspiring many terrible copycat bubble zone laws and for the country's first bubble zone, municipal bubble zone of its kind. This is a terrible award, and I hope that you are not proud of yourself for receiving it. So today I'll actually be visiting two of the communities that received our Municipal Muzzle Award runner-up. I'll be visiting South Bruce Peninsula and Caledon to present it. And I will be posting some live videos, so make sure you're subscribed so you can get notified. I'm not visiting Calgary because, well, I was just there. We actually are challenging the Calgary bylaw. Our legal challenge to that law was heard in February at the Court of King's Bench, and we are now awaiting a decision. And you might be wondering, what about these other bylaws listed in the report or the runners-up? And I would love to challenge them. And I would love to challenge many of the bylaws in this report. So go read the report. It's available at the ccf.ca. And if you see your town listed as one of the many in the report, because there are a lot, please send me an email. If you have been impacted by one of these laws or even charged under one of these laws, reach out to me at cvangeyn@theccf.ca. My contact information is also on our website, theccf.ca, because I would love to hear your story. So go check out the report and leave a comment below letting me know what you think of our winners and if you think one of the other bylaws I mentioned in this video should have been selected. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.